Welcome to Daily Justice Time.
All right, the court is going to call 2023 CR 5021 and 2022 CR 1748, State of Texas versus Miguel Angel Rangel. Can I have parties announced for the record, please, for the state?
Daniel Escobar for the state of Texas.
Orlando
Defense.
Castañon for defense.
And are you Mr. Miguel Angel Rangel?
Yes, Your Honor.
Counsel, in each of the cause numbers, have you received all of the discovery and did you review that discovery with your client?
Yes, Judge.
In each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Rangel, in each of the cause numbers, I'm showing you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do.
State, and cause number 2023 CR 5021, which is the evading arrest. Are you proceeding on the indictment as presented?
Yes, Your Honor.
And in cause number 2022 CR 1748, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count one, proceeding on count two.
Any objection?
No, Judge.
Mr. Rangel, in each of the cause numbers, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes, Your Honor.
In cause number 2023 CR 5021, you're charged with the offense of evading arrest or detention in a vehicle. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. In cause number 2022 1748, you're charged with the offense in count 2 of possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Do you understand?
Yes, Your Honor.
And each cause number, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
Yes, Your Honor.
Did you understand by entering into plea bargain agreements in each of these cause numbers, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea agreements in each of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defense in either cause number?
We were able to, he was able to assist me in his defense, Judge.
In each cause number, do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
And each of the cause numbers, do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Rangel, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the pleas?
No, Your Honor.
Has anyone promised you anything other than the pleas?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain page. Did you review those pages with your attorney and did you understand them?
Yes, Your Honor.
In each cause number, the state is asking that your punishment be assessed at 8 years in the prison. There are no applications. The cases will run concurrently. They will take in consideration 2023 CR 5660, 2023 CR 5022, 2023 CR 5023, 2023 CR 5687, County Court cause number 654275. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Judge.
And each cause number, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Then in cause number 2023 CR 5021, how do you plead? Guilty, not guilty, or no contest? And in cause number 2022 CR 1748, how do you plead to count 2? Guilty, not guilty, or no contest?
No contest.
State, and Each cause number, do you have any evidence to support the defendant's plea?
Your Honor, in each cause number, the state offers State Exhibit 1 and all attachments.
We have no objections.
And each cause number, Mr. Rangel, I'm showing you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review those documents with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You're gonna have to speak up. You'll need to speak up.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
And each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. And each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
And cause number 2023 CR 5021, the court will sentence you to 8 years in the prison. Give you credit for any time served. This will run concurrent with 2022 CR 1748. Taking consideration 2023 CR 5660, 5022, 5023, 5687, and County Court cause number 654275. Is there anything else with regards to sentencing in that cause number?
No, Judge.
And cause number 2022 CR 1748, the court will sentence you to 8 years in the prison. Give you credit for any time served. This will run concurrent with 2023 CR 5021, taking consideration 2023 CR 5660, 5022, 5023, 5687, and County Court cause number 654275. Is there anything else with regards to sentencing in that cause number?
No, Judge.
In each cause number, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document? Well, those documents with your attorney. Did you understand them and did you sign them?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
And counsel, I will give you the dismissals. Can you have them sign that?
Yes, Judge.
Oh, no problem.
One of those is a county clerk.
Yes. All right, we can go off the record. Mr. Rangel, let me just tell you about your actions that day. Because of what you did, that person who pulled over, who was trying to help the person who really didn't need any help with a flat tire, because it appears that you all were working together, that person now will probably never stop just to help someone else who may truly be in need. And that makes for a snowball effect. So there may be somebody pulled over to the side of the road. It may be somebody who's pregnant in dire straits, and that person is going to pass them up and say, well, the last time I tried to help somebody, they were actually conning me. You're going to have to start making better decisions, and you need to ask yourself, was stealing a vehicle worth 8 years of your life? You understand? All right, good luck to you.
Bill, these are your copies real quick. The current opinion that he's been instructed to not communicate via third party or directly.
Oh, just 1 second. Let me call the case and then we'll. All right, court is calling 2021 CR 1906, State of Texas versus Kevin Owens. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Orlando Castaño for defense.
And are you Kevin Owens?
And so that is what I'd like to address is he is of the opinion, because the proceedings are live streamed,
Mhm.
that any statements he makes is him communicating to whoever.
All right,
So he was asking for an order that he be allowed to speak while in court.
I mean, I'm asking you a question, so obviously I want you to speak. Are you Kevin Owens? That's either yes or no.
Yes.
All right. So there has been a motion to withdraw attorney.
Yes, Judge.
All right.
And so I also followed the motion to modify conditions. I'm not sure whether you want to address both.
Well, let's address the motion to withdraw first, and then we'll see if we get to the other motion.
I've represented Mr. Owens now for just over 2 weeks. We met last week at my office, and during the duration of our my representation, he and I have had differences in regards to how to proceed on this case. There has been, I believe, a strong difference in opinion on how to proceed. He's asked me to do things that I do not agree with. And in that disagreement, because I've not wanted to move forward the way he's asked me to, he's notified me in writing that I was fired. And so he asked me to file a motion to withdraw, and I've done so. I believe at this point, though, that our disagreements are fundamental and that I cannot ethically represent him.
All right. So, Mr. Castagnone, I believe you're the third attorney on this case.
I believe I'm the second.
The second. All right. I thought there was someone before Miss Gay.
Ms. Gay, and I believe she was the first lawyer on this.
Let's see. All right. Can you look in the record and see if Miss Gay was the first attorney on this case, please? All right. So this is scheduled for trial October 9th. So your motion to withdraw will be denied. Mr. Owens, if you wish to hire another attorney, you're more than welcome to do so. But whoever that attorney is, they're going to need to be ready for jury trial on October 9th. So,
Judge, I don't believe I can ethically, again, as I stated, represent Mr. Owens. And I believe that eventually he not wanting my representation, I believe that this is an issue that is an appealable issue. And I don't believe that I can ethically be his attorney at this point.
all right, motion is denied. The next motion is the motion to modify or delete bond conditions.
Yes, Judge.
All right. Counsel, you want to address that?
Yes, Judge. We've asked, my client is indigent, as you know, that I have been appointed on this case. And previously, I believe Ms. Gay was appointed. I'm not certain of that, but I do know that I have been assigned to represent him. He's asking that his GPS fees be waived because he is indigent. I did not put this in the motion. I forgot to add this, but I did speak to the state in regards to his request. He also would like to have drug test fees waived because he is indigent. And so he has recently had to provide a drug test, and it cost him $10, and he's struggling to have money. He's not been able to work. The other issue he's asked me to address is that he'd be allowed to have tracking only. And the facts of this case do not demonstrate that he has gone to any individual's business, home. These were all through electronic communications. And so I do not believe that GPS is necessarily something that's going to prevent any of those types of issues. So we'd ask that tracking be allowed. He's been having a difficult time finding employment. And he did recently find employment with Toyota, but his understanding is that he has to have the employer come in and testify as to his employment. And because of that, that was prohibitive, and he was not able to maintain that employment. And so, that condition, if the court does not wish to allow him tracking only, we'd ask that that be removed, or in lieu of in-person testimony, that there be some type of, ability for an email with company letterhead or something acknowledging that he has been employed. Because he is indigent, he has not been able to retain his own attorney. He can't afford GPS fees. And so it's important that he gets out there and begin working.
All right. State.
Your Honor, I think that the court wants to waive the fees. I think that's reasonable. With the GPS, we would ask that you keep the GPS the way it is with full house arrest. The code says that the court can make reasonable conditions as part of bail. And I think that's a reasonable condition. We think the defendant has been doing well because of the GPS, not in spite of it. So we would ask that you keep that in place. The part about the order, the defendant being able to speak in court, I think you addressed that in the last motion, but I mean, we don't have any objection to that. We want to be able to speak while he's in court. And any conditions with employment, I think that's up to you, Judge. So we don't have an opinion there.
All right. Is there anything you wish to add, counsel?
No, Judge.
All right. With regards to his speaking in court, I mean, that's very broad. You don't want somebody to be inappropriate. However, if there's something he wishes to say,
I believe
can't
his concern is also just acknowledging his presence, Judge. So any speech that he made or makes, he was under the belief that he would be in violation of a court order.
No, I never put a court order in place that he could not talk. But I will say this. I can't give you any legal advice, but I know that anyone who had a criminal case or any type of legal case would perhaps want to speak to their attorney before they decided to speak to the court. But that's completely up to your relationship with your attorney. So I think that's overly broad. So I'm not going to rule on that.
I think he was looking for an order just allowing him to address the court. Should he be asked to speak, asked to announce it present? And if he were to testify, that he'd be allowed to testify.
Yes, of course he can. If he decides to testify, then you're welcome to testify. That's within your purview to make a decision. A client in criminal court has certain rights. One is whether they enter a plea or not, whether they go to the court or the jury for punishment, whether or not they decide to testify or not testify. So I really don't understand the defendant being permitted to speak while in court, that request, but I'm telling you, you can speak in court. With regards to the GPS fees, I'll ask that those be waived or deferred. With regards to employment, counsel, if the issue with the employers testifying is because there was no documentation that was being brought to the court when there was a issue of whether or not he had employment, and the court wanted to know what employment he had, what the hours were, and what would the job entail. Because of the nature of what he's charged with, the court didn't think it would be prudent for him to have employment where he's not at a stationary place.
And I understand that, Judge. I believe that the facts of the case do not warrant restriction of his movement because he's not been, I believe, accused. It's not alleged that he's been traveling to or anybody's residence or business. And so, I mean, it seems to be just a bit of an overreach in regards to restricting his ability to find employment.
All right, so I'm going to order that he has to provide proof of employment, and that includes his work schedule.
And so just to clarify, when you say provide proof, would an email from the letter or a letter from the employment with letterhead, would that be sufficient proof?
But it'd have to have what his work schedule
Correct.
is. Yes, and counsel, I'll depend on you as an officer of the court to verify that that is
Absolutely.
correct. All right.
Just so I'm 100% clear that you're not requiring that his employer come in and testify to such.
No.
Okay.
And then with regards to him being permitted to speak while in court, sure, he can speak while in court. With regards to tracking only, that's denied.
And I didn't list it in there, but there's space for it if the court approves permission to waive any drug testing fees. I don't know if the court has the ability to do that, but
I will waive drug testing fees. All right. Is there anything else with regards to this motion?
right. And so he has been including me on emails. He does have household duties such as going to HEB. And so, he would like to be able to go at least once a week to get groceries. He did ask for permission to go to the post office. And so I believe he would like to at least be able to go because he's been having them delivered, which is a fee.
Mhm.
And it costs additional monies to have those groceries delivered. And so he would like to at least be able to go to HEB and pick them up.
All right. That will be denied. Is there anything else?
Good judge.
All right. So you all will be back here on October 9th for jury trial. And we'll go from there. Is there anything else?
No, Your Honor.
No judge.
All right. Do you need a reset form, Mr. Owens? I'm sorry.
Do you want a reset form to show that we're going to be here on October 9th or?
Yes. All right, Ms. Ferguson, if you can give them a reset form for October 9th.
The court heard two cases against Miguel Angel Rangel. The judge confirmed that both attorneys had reviewed the evidence and that Miguel had reviewed and understood the indictments with his lawyer. Miguel was charged in the 2023 case with evading arrest in a vehicle, a third-degree felony, and in the 2022 case with possession of a controlled substance between 4 and 200 grams, a second-degree felony. The judge explained the possible punishments and told Miguel that plea bargains are not guaranteed, but if the court gave a higher sentence, he could withdraw his plea. Miguel said he understood his rights, including the right to a jury, the right to confront witnesses, and the right to remain silent, and he agreed to give up those rights to enter a plea. His lawyer confirmed Miguel was competent, understood everything, and was not forced into the plea. Miguel accepted the plea deal in which the state recommended 8 years in prison, with both cases running at the same time concurrently, and other pending cases taken into consideration. Miguel also signed a waiver giving up his right to appeal. He then pled guilty in both cases, and the judge reviewed the evidence, found it sufficient, and declared Miguel guilty. The judge sentenced him to 8 years for each case, to run concurrently, and gave him credit for any time already served. The judge reminded him that, because of the felony convictions, he cannot own or possess firearms. Before ending, the judge spoke to Miguel about how his actions affected innocent people and warned him to make better decisions in the future, emphasizing that stealing a vehicle was not worth losing 8 years of his life.
Please like, comment your view, and subscribe to my channel for more real stories.